Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. We will be discussing some aspects of the fire and also how landlords are facing a broken legal system. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is January 11th, 2025. The song Bad Day by Daniel Powter, released in 2005. It actually was the #1 song according to Billboard for the year 2006. And I thought it was a very poignant song to play today due to the upheaval, the tragedy that is affecting all of Angelenos with this fire issue. My heart goes out to all of the people who have families who have lost lives or who have lost property. It is truly a dramatic situation here in Los Angeles that I'm sure we're all praying for it all to be over. I do want to first talk about issues relating to the fire. And before we get into the topic of the day, which is dealing with landlords and how the legal system is broken for landlords. But with regard to fire issues, I don't think it's really productive at this moment to start assessing blame as to who's at fault. But I do think we do need to concentrate on fixing the problems. So what's the problems? Well, I think everybody knows you're dealing with forest and land management, that dramatic steps have to be taken to clear these areas so that the fires don't break out as easily as they can. A lot of these current policies were based on environmental issues, ladies and gentlemen. But the truth of the matter is, if you want to talk about chaos for the environment, let these fires rage. So I think you got to pick your poison. And I think based on human life and destruction of property, in addition to the environmental catastrophe that we're now suffering in Los Angeles, I think we need to reassess our land and forest management. The other thing that obviously we need to do, and again, I'm no rocket scientist, that we have to have adequate fire personnel. We can't be cutting budgets. It's just total insanity, ladies and gentlemen. And also, we have to deal with insurance issues. Um, the insurance companies have to make a profit. No business is out there to lose money. So the working with the state of California to ensure that insurance companies are made profitable, and maybe in conjunction with the California Fair Plan. But we have to demonstrate to these insurance companies who are running out of our state that you can make a profit here. No business wants to be in a place where you're just going to be losing money year after year after year. So this obviously has to be, these insurance companies have to be working with our state government to ensure, or maybe even our federal government to ensure that they're profitable, but that Californians are able to obtain proper insurance for their house. I know my house was canceled. I know my son's house was canceled, and we had to go into the California Fair Plan, which in many cases, for many Angelenos, it's not adequate insurance. So this has to be really a governmental problem that needs to be solved in conjunction with these insurance companies. And again, I don't hold these insurance companies in a bad light. They're just trying to make a profit, but we have to make them in a situation with working with the government that they can uh, reasonably insure Californians and also at the same time make a profit. The last thing that we need to talk about is water issues, that we have to allow the water to flow from the Northern California to Southern California. Whatever environmental issue is stopping us from doing that, we have to understand what has now occurred because we don't have an adequate water supply here in Southern California. So those are my issues dealing with global issues dealing with the fire. But we also have to talk about, since this is a landlord tenant show, we have to talk about how the fire is affecting landlords. We have just gotten tons of questions as a result of this fire epidemic in terms of landlords and in terms of them managing their own property. First thing I want to address to everybody, and you might not be aware of this, that for any loss of property due to fire, you might want to consider hiring public adjusters. Public adjusters are companies that will work with your insurance company. Insurance companies, they don't want to pay the maximum amount. They'll review your policy, and these companies are adept at getting every single dollar that you possibly can get. I don't have any recommendations for a public adjuster. I did have a building that caught on fire many years ago, and we used one. They were great. They got us loss of rents. They took care of our tenants based on what the insurance policy that we had at the time. So if you guys have suffered losses as a result of this fire, I would at least explore the possibility of not just dealing with your insurance agent, but to actually hire a public adjuster. Whatever their cost is, it might bring money back to you in spades. With regard to tenants that are displaced because of evacuation orders, where there is no problem with the premises, they were just in a spot where they were told by the local government to evacuate. The issue is there any compensation that landlords need to make to these people? I get this question all the time. And so I'm raising it because of the issues that we're getting at our office. And the reality is that that there is no responsibility on the part of the landlord to make any kind of a relocation assistance or an abatement of rent because the tenants were forced to move by evacuation orders. This is an act of God, and it really has nothing to do with the owner of the property. So technically, the tenant owes rent. Technically, you're entitled to your rent, though you might want to make a rent adjustment due to the situation, landlords. But in terms of the legality of doing that, there is no obligation on your part. The issue then comes up with what if you had an apartment building that, God forbid, was destroyed in the fire? The issue is there any relocation that needs to be given to the tenant, any compensation for their loss of property? And the answer is no, there is nothing. Can the tenant come back to the premises after the units are rebuilt on the same premises? And the answer is no. Under Civil Code Section 1933, destruction of the premises terminates the tenancy. So once the premises were destroyed, at that point in time under California law, there is no further compensation to the tenant. Hopefully the tenant had procured their own renter's insurance, which would compensate them for loss of their personal property and for possibly moving expenses. But again, this is not an obligation on the part of the landlord. The last thing I want to talk about is what if there's like a partial damage to your property? Is there any compensation that's required to give to the tenant? And the answer for most jurisdiction is no. There is no thing. If the tenant can't live in the place while the place is being renovated, there is no compensation to the tenant. Some jurisdictions like Los Angeles, which has the rent stabilization ordinance, would require that you do pay them compensation, and then once the premises are restored, they'll allow them to come back. But again, this is only where there's partial damage to the premises. If the premises are totally destroyed, then under Civil Code 1933, that terminates the tenancy under California law. So that's my basis of discussion with regard to the fire. I might have some more comments about that next week, Saturday at 3 p.m. when we do our next show. But those are the key highlights that I did want to talk about. However, I did want to move on to why the legal system is broken for landlords. having nothing to do with our fire epidemic at this point. And getting into that topic, which was the topic of the week, and the reason why our legal system is broken for landlords and income property owners is that, number one, it's impossible for mom and pop owners to navigate these procedures dealing with landlord-tenant issues. It's absolutely impossible. The legal requirements are insane. No one's going to know this. So it's literally forcing landlords to hire an attorney because, quite frankly, you can't do this by yourself. It's almost impossible now to serve your own 3-day notice and have it be legally sufficient. Why else is the legal system broken for landlords? Well, one of the wonderful state laws, and I say that facetiously, is that almost all unlawful detainer cases, eviction cases, the legal records are hidden, they're masked, which means that a tenant can sit there and go through an eviction case, be found guilty of legitimately not paying rent, and then move to another place. And the new landlord attempting to look up any record of the tenant showing that the premises were based on an eviction will not be able to see that. So it's allowing these tenants to move from place to place to place, causing thousands of dollars of lost rent and also damage to the property to landlord after landlord. And the landlord is powerless under this ridiculous legal system to protect their own property and to run a proper credit check. Now, there are legal requirements dealing with now the state, regular general state laws, and now under statewide rent control. The laws are so crazy that while there are exemptions for single-family homes, condos, and townhouses, that there has to be certain language that has to be contained in your rental agreement. And if it's not, then your property, which would otherwise be exempt from statewide rent control, is now subject to rent control. This is just one aspect of why this legal system is broken, while it's impossible for landlords to navigate through this mass of laws. But as we get there, let's move on to local jurisdictions. Every jurisdiction has different rules locally, from the city of Santa Monica, the West Hollywood, Los Angeles, Pomona, Cudahy. They all have their own jurisdictions. They all require, certain ones require registrations. Certain ones have certain notice requirements based on that local jurisdiction. Some places have, for example, the city of Los Angeles and unincorporated areas of LA County require that you can't serve a 3-day notice unless the total amount in that 3-day notice is above the fair market value. Who really, unless you do this on a regular basis, who's going to know all these requirements? So what they've done, ladies and gentlemen, they've made it totally unmanageable for landlords to navigate these legal procedures. It's absolutely insane. Then we move on to Section 8. The state of California, under their laws, are requiring that landlords take Section 8 tenants, that you can't even reject an applicant who's Section 8 based on credit. Insane, ladies and gentlemen. As of January 1st, 2024, you can't reject a Section 8 applicant based on his credit. They now have this requirement of ability to pay. So if the tenant has the ability to pay that small portion of the Section 8 rent, then in that situation, you have to accept Section 8. Well, what's the problem with Section 8? Well, in addition to having the government in your pocket as a partner and having to go through inspections and all that, we now have under Section 8, if you have a Section 8 tenant, even one in your building, you don't serve a standard 3-day notice to pay rent or quit. You have to serve a hyper notice called a 3-day notice to pay or 30-day notice to quit. So you're going to give the tenant 30 days longer on the property. And that's if you have one Section 8 tenant in your building, that requires now that you have this notice, this 3-day, 30-day hybrid notice to pay rent served on any tenant that you have on the building. Also, for example, I mentioned that the city of Los Angeles and unincorporated areas of LA County require that you can't serve a 3-day notice unless that notice is above the fair market value for the certain amount of bedrooms that you have. Well, if you have a Section 8 tenant where the tenant is only paying $200 out of the $2,200 rent, what that means is you can never evict a Section 8 tenant based in Los Angeles City or unincorporated areas of LA County based on non-payment of rent because you'll never be above the threshold. These are the reasons why it is insane being a landlord, a rental housing provider in the state of California, and certainly where all these juries, where these jurisdictions, these local jurisdictions that have just a myriad of rules. But let's move on. When we get to the legal system, the common ploy now is for tenants to ask for jury trials. In the state of California, anyone can ask for a jury trial. It's not up to the judge to grant it. If you're a tenant, you want a jury trial, you get a jury trial. So what does that mean? It means that for landlords, the cases are delayed because there's not enough courtrooms that can hold for juries. You have to have a certain amount of juries, like 15 to 20 juries, to pick before you can actually start the trial. It also creates a tremendous extra expense than if you had a bench trial, that is a trial just in front of a judge. The paperwork required for a jury trial is tenfold what the paperwork is required for a regular bench trial. So this just creates further delays and expense for landlords. And the trials get delayed and delayed and delayed because legitimately there's not a courtroom there. So what happens? Landlords faced with a tenant owing thousands of dollars of rent are forced, based on the system, this broken system, to basically give up all their rent and in some cases pay this tenant who hasn't paid rent, pay this tenant to get out, because on an economic basis, it makes more sense to give up thousands of dollars worth of rent and pay the tenant a few $1,000s to get out based on our system. Hence, the reason why I say that the legal system for landlords in the state of California is entirely broken and needs to be fixed. We are housing providers. We provide such a valuable service to the citizens of California, and we need to be taken care of too. These laws that are all based on protections of tenants, these laws are so overwritten. What we need is laws to protect landlords. We need laws that protect landlords from tenant harassment, not the other way around. So, what's the solution? Well, I've got a couple here. And that is that if you don't, and this is other states do this too, if you want to contest the proceedings where you're being evicted by your landlord, then you need to post the rent that's owed. If you're claiming that you're withholding the rent for habitability reasons, that the landlord wouldn't fix it, then you need to post the rent. So one solution would be, if you want to be able to contest the proceedings, post the rent with the court. If you win, you get it back. But you can't be claiming that, hey, I'm withholding rent because the landlord didn't fix the property. So make it a law, politicians, that a tenant cannot contest the proceedings unless he posts the rent that is stated in the eviction paperwork. Another way to do it, which be a little bit less dramatic, is let the tenant contest the proceedings. But if you want to claim habitability, which they do in all these cases, and they're all phony claims of habitability where they never told the landlord that something was wrong with the premises. But if you want to contest the proceedings, then at very minimum, post that money with the court, post that rent with the court. If you don't, then you can't claim habitability in an unlawful detainer case. That will dramatically streamline the system. So politicians, I'm telling you to get up, get off your ass, understand what housing providers, the wonderful job that housing providers do for the citizens and people of the state of California, and allow us to be a prosperous industry like every other industry in this state. And with that, ladies and gentlemen, I'm going to get off my soapbox for the day. We are going to open it up to questions and answers. The rules are, if you do want to talk to me, please electronically raise your hand. You can, if you're in the Zoom room, you can do that. And I'll be happy to call on you. I do see we have a lot of callers right now. Remember that these broadcasts are for informational purposes only, and it is not a substitute for legal advice. If you do have a case with me, remember we only talk about general questions of law, do not talk about specific cases. You can always call us at the office for that. And last but not least, to make these broadcasts more enjoyable, if you do have a camera, please turn it on when you're talking to me, because I think it's more enjoyable for me to see you and for everybody to see each other. And with that, we're going to open it up. Our first caller of the day will be Dorian. I'm going to ask you to unmute yourself.
Hi, Dennis. Sorry, nothing's working this week, including my camera. So I apologize. So I'm trying to get my head around there's a new JCO requirement. Uh, you have to pay 3105, and I called the housing department, but the lady didn't know anything about it. She said they just told them about it. So I asked them if I need to pay it or not. She wasn't quite sure. She said if it's not RSO, which my condo is not RSO in Los Angeles, and then I asked her how do I pay, and she said you'll get something in the mail. I got something in the mail, but it's for my RSO property, so I'm not sure if I need to register, given that I did give my tenant in the lease the AB 4982 exemption. So I don't know if that applies or not. And the second thing is, how do I register? Because no one seems to
All right,
know.
let me stop you because you're going through too many issues here.
No, no.
First of all, for the ladies and gentlemen listening to this, you're talking about property that's located in the city of Los Angeles that is not subject to the rent stabilization ordinance, which is RSO. Any property not, any residential, I don't care what it is, not subject to RSO is going to be subject to the JCO, the Just Cause Ordinance. There's nothing to register for the Just Cause Ordinance. I did hear some noise that they're going to try to charge landlords for inspection. So there might be, quote, an inspection fee, but I haven't seen that actually has come to fruition. So I would just wait it out and wait till you see if you get something in the mail with regard to your Just Cause Ordinance properties as opposed to your RSO properties.
Thank you.
All right, you take care. Moving along to Tara Lewis. How are you?
Great, Dennis. Thank you for your time today. Okay, I have a RSO property. It's a 5-unit RSO property I purchased in 2014. And from all the tenants that were there, they all filled out estoppel statements. A couple of the units, they also had the original rental agreements that were included with the estoppel agreements from all the tenants that are there at the time. In the garage, there was this washer and dryer that was non-coin operated. It was just a residential washer and dryer in the garage area that was, I guess you would call that the common area. 2 years later, after I purchased the property, I installed a coin-up washer and dryer. Two of the tenants immediately complained and said that the washer and dryer was included with their rent. And one of the tenants of the two claims that she had it in her original lease agreement, which I didn't receive a copy of. All I received was the estoppels from everybody, and not one of the estoppels.
Let me slow you down. This is a RSO property in Los Angeles.
This is RSO property in Los Angeles.
Okay, so then let me advise you. When you bought the property, okay, the washer and dryer, which were not coin operated, were there. So the RSO would consider that to be an amenity that came with the premises. And if you changed it to now a coin operated, then technically you are in violation of RSO. The fact that you don't have a rental agreement which provides for it, or there was nothing in the estoppel, is somewhat irrelevant. There's nothing in your estoppel, there's nothing in any rental agreement that says that there's a toilet in the unit. So based on your process, you'd be able to remove all toilets, and obviously that would be ridiculous. So the fact that the washer and dryer was there and it was in a common area and all the tenants used it, I don't think you can charge for the now make it coin operated. I think you'd be in violation of the rent stabilization ordinance.
Okay, because yesterday the tenant that was making a big issue about it, she found her 23-year-old rental agreement, and it states in there, it just says water, space, laundry, owner's responsibility. Does laundry mean I have to pay for it? Is that what that means?
Well, again, if whether it was in that rental agreement or not, if there was a washer and dryer that from day one tenants used when they moved in, that would be considered an amenity that went with the premises that they were leased. If you had something in one rental agreement that said this is an accommodation that can be removed at any time, that would be a different story. But if there's nothing that says that, then what comes with the premises is their amenities, and you have to compensate them for that.
Okay, because this one person says she's going to file with the housing department over it.
I think she'll win if she does, Tara.
Okay, secondly, that the same tenant, she claims that she had mold in her bathroom. So she took me into the bathroom, and I noticed that there was peeling paint above the tile, between the top of the tile, at the top edge of the tile on the wall. I said, that doesn't look like mold to me. I can scrape that off and paint it and take care of it. She says, well, no, I think it might be mold. So I want to bring somebody else.
If she's stating that she thinks it might be mold, it's your obligation to go check it out. You don't have the knowledge to know whether that's mold or not. And if you have peeling paint, that could be something of a bigger issue, something that's behind the ceiling or the wall that's creating this issue. So on that basis, Tara, I would tell you to take care of it. We're going to move along to Holvik. I'm going to ask you to unmute yourself.
Good afternoon, Mr. Block.
Hello, sir.
Thank you for the opening topic. Definitely do feel that as we progress in the current environment, that us landlords are getting harassed and threatened on a regular basis. So thank you. My question today is, I initiated an eviction, I think in November. Tenant very recently moved out on his own will, gave me keys and the keys to the common areas and the mailbox. I have 21 days to give him the deposit itemization. However, I'm not sure how I can do that. When I did go pick up the keys from him, he got very hostile and aggressive towards me, and I didn't get a chance to ask him his forwarding address. So I don't have an address to mail it, and
okay, well, that's no problem. The tenant's obligation is to give you his forwarding address. You don't have an obligation to ask for it. If he doesn't give you your forwarding address, you still must mail it within 21 days, and you mail it to the last known address. The last known address would be your property where he vacated from. If it comes back to you as undeliverable, then just hang on to it. Don't open it up. Leave it sealed. And if you ever get sued, you can show the unsealed or the sealed envelope to a judge. So as long as you mail it to the last known address within 21 days, you are fine, Hovik.
he doesn't have an argument saying that he gave me the mailbox key, so he has no access. Am I safe?
Well, the concept, he's not coming back to the property. The concept is when people move, they file a change of address with the post office so that it gets forwarded to them.
I see. Okay, understood. Thank you, Dennis.
All right, no problem. Okay, Austin, how are you this weekend?
Hey, pretty good, Dennis. Can you hear me all right?
I can.
All right. I got an easy one. So I signed a year lease with some inherited tenants. This is a fourplex in the city of Long Beach, and I'm owner occupying one of the units. About 5 months into the tenancy, I started seeing a younger individual in their 20s hanging around the unit, and they introduced him to me as their son. And I thought he was just visiting, but it looks like he's staying there pretty routinely. And I think by all accounts, he's an additional occupant. So we are in a year-long lease already, and I want to bump up the rent. And my lease allows for a $100 increase. Do I just do that on a signed addendum by all parties? When they signed the lease in August, I already raised them 8.9%. So I don't know if I can raise them anymore, but the lease does allow for additional occupants just for an additional fee of $100 a month. So I want to talk to you about that.
Well, first of all, your property is subject to the Long Beach statute, and I don't know that they have their own rent increase requirements. It does follow statewide rent control, but the problem is that under statewide rent control, they don't allow for additional payment if an extra person moves in, additional rent. So you're in kind of a gray area. Now, one could make the argument that, hey, I'm not really increasing rent at all because the rental agreement specifically says this is what the rent is, but it's 10% more if an extra person moves in. That would be the argument that I would use, but this has not been tested in any court. So I don't really know that you have the legal ability to raise it. You do have the legal ability to evict, but I don't think you really want to do that.
Yeah, I mean, his name is not on the lease currently, but he is an adult. He's 25 years old. They told me that he, is moving back into the apartment, or, moving back into the apartment from Houston where he was staying with his mom at the time. But, yeah, I guess that is kind of a gray area, but at a bare minimum, if he wants to stay, he has to at least sign an addendum to the lease saying that he's read the terms and
Yeah, I
conditions,
mean,
right?
yeah, at the very minimum, but I mean, you might want to just, throw caution to the wind and have everybody sign a new rental agreement with his name on it and bump it up. I mean, the worst that's going to happen is that you'll have to give the money back. And again, this really hasn't been tested. So anyway,
Okay.
thank you very much, Austin. Please drive carefully because it looks like you're driving now. And we are moving on to Nooni. How are you today? Nooni, are you there?
I am here, Dennis. How are you? Here
I
I
am
am.
fine, thank you.
I I had a question because I had been granted a writ of possession that's gonna be scheduled for the 28th of this month. Well, she has to be out on the 20th, but the sheriffs are saying they will schedule it for the 28th. But she called this morning about 1:30, and she was asking if I can send out an electrician. So I was wondering, am I obligated to do
Regardless of
that?
whether you're in the middle of an eviction case or not, if there's something wrong with the premises, the law specifically states that the landlord is responsible to take care of that. So if she's got no electricity, and that's a result of something going on at your property versus on a local level, then I would definitely send an electrician out to figure out what the problem is.
Okay, sounds good. Thank you so much.
Good question. Moving on to an oldie, Jim Polina. How are you, sir?
Mr. Dennis Block, good to see you. It's been a few weeks.
Yes.
So, I intend to buy a foreclosed property at auction. And I heard what you said before regarding the Protecting Tenants at Foreclosure Act. And if the house has a tenant in it with a long-term lease that is protected by statewide rent control, can I still give that tenant a 90-day notice to move out because I intend to move in?
You say, what, first of all, what city is this?
Probably Sacramento, but it could be any city.
Okay, because certain local jurisdictions do have laws regarding this specifically. You're telling me this tenant has, quote, a long-term lease?
Correct.
Okay, so generally under California law, a foreclosure terminates any lease. So I would think that the lease would be terminated and you could then serve a notice that you're going to be moving in.
Well, I thought
Wouldn't be true if there's a local rent control for that area, though.
this Protecting Tenant Foreclosure Act, I think that's a federal act that allows the lease to live through a foreclosure, and the new owner has to honor it, with an exception if the buyer of the foreclosed property intends to live in it.
Right.
Then he can give a 90-day notice for that tenant to move out.
That is accurate. Correct.
It is accurate. Does that apply to Section 8 tenants as well?
Yes. I mean, Section 8, one of the reasons you can even evict for Section 8, even for economic reasons. So yes, certainly on the desire that the owner wants to move in.
Okay. All right. Thank you, Dennis.
All right. You take care, sir. Moving along to, I see an iPhone here. That's all it states. I'm going to ask you to unmute yourself, or you can hit *6 if you're really on a phone.
Hey Dennis, how are you doing today?
I am fine, thank you.
I do have a question. I have a tenant that's currently, well, I'm in the middle of an eviction right now, and the tenant has brought up something interesting. I provided services at my building, like where the tenants can receive their packages. It's called partial pending. They get their packages there. But he brought up the fact that we actually cut that service to him during the eviction process, that along with the online access. And the reason why we cut the online access, because we didn't want him to make unauthorized payments. Do you think that's going to be an issue, like we cut services or
Well,
reduction in services or something? Or I don't know how that will work.
the issue only is what services you cut when you serve the initial 3-day notice. Anything after that should not affect your eviction case whatsoever. However, if you do cut services, he would have the right to file a separate suit against you based on the fact that you're supposed to allow all services to continue, with the exception of the portal where he pays his rent to. That certainly you could cut because you don't want him to pay the rent. So that's not a service to his benefit for him to be able to pay you rent because you're not accepting his rent.
Okay, and I think what had happened was we cut the service on the parcel pending when we served him the first 3-day notice. They did pay the rent on that 3-day notice, but the following month, um, they didn't pay the rent again, but we never reactivated the services.
Right, and I don't see that,
Yeah.
you're allowed to withhold rent based on a substantial problem dealing with the habitability of the premises. This has
Okay.
nothing to do with habitability, that he can't get his packages at some location.
Okay. All right. Thank you so much, Dennis.
Good question, sir. Moving on to Noel Diaz. I'm going to ask you to unmute yourself.
Hey Dennis, can you hear me?
I can.
Perfect. Thank you so much for everything you do. And I'm sorry I'm not turning on my camera. I'm actually on the road, but I just had a question. I have an RSO property, which I purchased last year in March. It's in the city of San Pedro. It's a triplex, and I have the intent to move into one of the units as an owner occupier. One thing that I've been debating on to do an owner occupier, or whether to take the tenant to court, or start an eviction process, or because he is violating the terms of his agreement. He made modifications to his unit. He's an electrician, so he made quite substantial modifications.
Now, did he do these modifications before you became the owner or after?
They were done before.
Okay, I don't think that's a good
Yes.
case because she's going to claim that the previous owner allowed it or knew about it and didn't take any action. So it might be considered a waiver. So if you do want to move in, then I would probably use that. If he had made any alterations once you became the owner, that would be a different story. Now, for this triplex, do they all have the same amount of bedrooms?
I'm sorry, can you repeat that? Sorry.
Do they all have the same amount of bedrooms?
No, there's two bed, one bath, and there is one bed, one bath. And so I know that I did speak to LA Housing, and they said that I am allowed to do an owner occupy as a mom and pop. And so this person is actually the person that has the least amount of years living in the unit, under 10. He doesn't have any children. He's not over 65.
Yeah, so for the amount of bedrooms that you want to pick the last person who moves in. That's what the city is going to require. So last in, first out. And again, if the tenant was over 62 and had lived there longer than 10 years, then that tenant is exempt.
Got it. Okay. Thank you so much. I'm gonna, I guess, go with that option.
All right, we are moving on to Mike Deseri. I'm going to ask you to unmute yourself.
Okay, Dennis, can you hear me?
Perfectly.
All right, excellent. Great show. We tune in every week, and it's just phenomenal, the information you put out. It certainly has saved me a lot of money. And that's my question, dealing with rent. We currently have a single-family residence that's vacant. We're in the process of cleaning it up, getting it ready to be put back on the market. Ideally, February 1 is the date. My question is, we're also going to be putting an ADU on that piece of property, but we're probably 2 years out from breaking ground. If I bring in a new tenant and I charge them $2,800 per month, let's say, and I tell them, look, when we break ground on the ADU, we'll reduce your rent down to 2,400 due to the inconvenience of having to live there while construction's going on. But then once the ADU is completed, is it possible to raise their rent back up to what it was, 2,800, in 1 month, or is there going to be some issues with that?
As long as you spell it out specifically in the rental agreement that when I break ground, it's 2,400. The moment I stop construction, then the rent is automatically returned to this amount without any further notice. You spell it out in the rental agreement. But if you're asking me my opinion, I wouldn't have any reduction. I would just put a phrase in the rental agreement that within the next 2 years we will be adding in an ADU to this premise, and just have them understand that that's what they're agreeing to when they move in. I wouldn't have any reduction in rent. I don't think that's a requirement or even economically a reason to do so.
Well, I'm just thinking of the pool of renters. Somebody might not want to rent it because knowing that an ADU construction is going to be happening there.
I
So,
would just I would add it at the end and just say, hey, by the way, in 2 years we're going to be adding this, and that's why I put that phrase in. I mean, you can kind of put your toe into the water to see how the market reacts to that, but I would first try to do it without any concession to the tenant.
okay, good point. Thank you very much.
All right, you take care, sir. We are moving on to C. McLean. How are you?
Hi, can you hear me?
I can.
Hi, Dennis. My name is Carrie. I have a Palisades Highlands condo, and it hasn't been destroyed as of yet, as far as I know. And so I'm wondering about my tenants. Hopefully, they'll be allowed back in at some point. My question is, if the power lines are down and there is no power, and we don't know when it's to be restored, obligation, what obligations do we have?
I don't think you have any. I think that was my opening topic. Obviously, this has nothing to do with the landlord, and this is more of an act of God. And
Oh, I can't
the
hear
tenants
you.
can't come back in. They
I
can't come
can't
back
hear
in.
you.
But
Hold on. I'm sorry, I can't hear you.
well, I'm sorry about that, but everybody else is. You might want to listen to
Oh
this
yeah, I can't hear
afterwards.
you.
Well, okay. Well, I'm sorry about that, but I'll say it off air for you that you can listen to this on the replay. But I don't think there's any obligation on your part to compensate the tenant. You might want to just do a diminution in rent for the time that they couldn't use the premises, but that's totally voluntary on your part, and it's maybe a good faith gesture. And with that, we are going to move on to Fred Morris. How are you?
I'm good, Dennis. How are you?
I am fine, thank you.
Okay, so I have 7 units in LA that I've owned for about 8 years or so. The tenants there to use the garages as storages. Now I'm in the process of getting, having those 7 units. This garages. I'm trying to build an ADU on them, and I'm meeting with the structural engineer next week. I had the management company send them a letter to clean up the garages so we can start the process. But he was telling me yesterday he's getting a lot of pushback. What is the best procedure, or what is the law in regards to that? If I was letting them use I wasn't letting them, but they used it as storages for the past few years. And now I'm sending them letters, want them to clean it up so we can start the ADU process. What is the best way to approach this?
Okay, well, first of all, did you lease to these people or they were there when you bought the property?
They were there when I bought the property, and their leases, all civil leases, doesn't indicate that they have garages, indicates they have parking, which we do have carports for all of them.
Okay, so are they using their carports for storage? Is that what I'm to understand?
So they're using the carports as intended in the lease to park, but the garages, they're using it for storage. So we sent them a letter, like I indicated, the management company to clean it up within 30 days so we can start, the ADU process. But the management company is getting a lot of pushback.
Well, I might want to take a look at the rental agreement. This is RSO Los Angeles.
Yes, LA City, yes.
Yeah, I might want to take a look at the rental agreements. So that might be a call to the office to see whether we can actually demand that they remove their stuff from the garage, that they were only given parking in a specific area and that they had no right to put it there. The problem, like I said to a previous guest, was that if they were using that as storage from day one, would that be considered a waiver since the previous owner never did anything with it? You might also, if we do find that this was kind of just part of their tenancy, we might have to make a demand for them to remove their items, their personal property from the garage area, and then give them a corresponding decrease in rent. But I'd have to review the rental agreement to be sure, Fred.
Okay, that's fine, but as far as the law indicates, because in their lease agreement, and I read every single lease, it doesn't give them any, it doesn't allow them to use those garages as storages.
Okay, well then we can try to, again, I would like to take a look at that, but again, we would then could serve them with a formal 3-day notice to remove your personal property from the garage, and if they don't, we could bring forth an eviction.
Okay, last question. When you take over a property, RSO, and has existing leases, like I've been using your leases for all the new leases that I'm doing. But if I bought property and had an existing lease for years, how can I use your lease, going forward? Is there
Well,
a
if it's
way I can do
RSO
that?
property, you can certainly give them a new lease, you're not changing the rental amount, and make a demand for them to sign it. The problem is that they have no obligation to sign it.
So they
But
don't
I
have
would
to sign.
certainly, yeah, I would just send it to them, say you've got 7 days to return it. You'll get some people who will return it. Sometimes you want to make some incentive for them to sign it by saying, you know what, I'll forego a rent increase if you sign my rental agreement. All right, Fred, thank you very much. We are moving on to Juan's iPhone. How are you, sir? Juan, are you there?
Hi, Dennis. Can you hear me?
I can, thank you.
Thank you for your services. I have two or three fast questions. The first one, I have a 2, a 3, and a 4 unit. They're all RSO. And in regards, to the postings for the tenants' rights, what happens? I posted them all, but the tenants rip them off. Which ones have to stay on the buildings?
Well, technically, there's one for RSO and then one for general tenant protection. So there's
Yes, I
really,
put both.
so I mean, I would just take a picture of it and show that you did post it. If they take it down, they take it down. Then when you're ever at the building, then, just have a bunch more in your hip pocket there or leave them in your car and put them back up.
Now, do they have to be on all the 2, 3, and 4 units, or just I know you said it
No,
once
for
before, but
every residential property, you need to post these notices.
okay. It doesn't matter how many units.
You got it.
Okay. And then this one's on security deposits. What happens if at one point before, when I first got my first unit, I allowed a tenant to come in without charging them any deposit, and about 5 years later he wants me to fix the whole unit, paint it, and fix everything that's wrong with it.
Well, first of all,
Can
the
I
security
charge?
deposit has nothing to do with fixing a unit. I mean, he didn't get a security deposit, but again, that was your choice. But that has nothing to do with fixing a unit. If the paint is peeling or chipping, then it's your obligation to fix it. We're not talking about cosmetic things. We're talking about specific uh, things that are wrong with the premises.
Yes. Well, this is more like damage that they've caused, like the doors are damaged, the light fixtures are missing, the glass part of it,
Okay, that
things
would
like
be
that.
something that they'd be responsible for. So you could say, listen, you're the one who created this. This is not usual wear and tear. This is unusual wear and tear. So you need to replace this, or I'm going to take care of it, and then I'm going to make you pay me for that.
And the last question, Dennis, I had a tenant move out, and I gave them estimated repair list, but I haven't sent them the finished receipts because, and I did that before the 21 days because they haven't finished the repairs.
As
Um,
long as you make it in your security deposit itemization that this is our estimates and the receipts will be coming as soon as I have them available. Technically, if you're deducting $125 or more from the security deposit, you have to include the receipts. But if the receipts or invoices are not available, then you can put a note there that they will be sent to you once I receive them.
okay. And how much more time do we have for that? Just whenever we
But
get
I
them,
mean,
we
it
send
should
them?
be very reasonable that you get the job done and get these receipts, my friend.
Okay. Thank you, Dennis. Appreciate your
Okay.
time.
All right, no problem. We're moving on to Albert. How are you?
Hi, Dennis. Yeah, can you hear me?
I can.
Okay. Thank you for your service and also help me to evict the tenants. I'm your client. So right now I have a tenant. They didn't pay my rent. On and off. So I'm planning to evict her out. So my question is, if he in the eviction process, if she pay like a partial, can we still proceed, or we cannot receive any payments from her? That's question
Is
number one.
this residential property?
Yes, yes,
Yeah.
resident property at Pasadena.
Once you serve a 3-day notice and the tenant doesn't pay it, if you accept any rent thereafter, then your case is lost. You'd have to restart it by serving a brand new 3-day notice. So once the case starts, if she tries to pay you a partial payment, do not accept it. You can, I would say to the tenant, okay, I'll accept all the rent if you also pay all the attorney's fees. And then this way, at least you're whole.
Yeah, my question is because they pay through the Zella, so I cannot reject any payments from her,
Well,
right? So if
that's not a problem. If the tenant makes a payment for Zelle, then you have two options if you don't want to accept it. Number one, Zelle it right back saying you've made an unauthorized deposit into my account. The second thing that you can do if you can't Zelle it back, then I would just get out your own personal check for that same amount, mail it to her with a note saying you've made an unauthorized deposit into my account. And that's not considered that you've accepted the rent when they themselves, by their own hand, put it into your account.
Okay, my last question is, if they pay the full amount for this month, then starting over again. So what we can do? We're going to start to serve the 3 days notice again.
Yeah, man, we have clients that serve a 3-day notice every month, and then they get the rent within the 3 days. Now, what I would do in that situation is, assuming you have a legal late charge, I would then start making a demand for her to pay the late charge. If she doesn't, then you can serve her with a 3-day notice to perform or quit, giving her 3 days to pay the late charge.
Okay, thank you, Dennis, for your service.
Thank you, sir. We are going on to M. Hong. I'm going to ask you to unmute yourself.
Hi, Dennis. Can you hear me?
I can.
Thank you again for hosting this. So I actually have a two-part question. So the first part is I'm renting out a single-family home, and we purchased the property about a year ago. So it's a year lease. The AC is old, but it's working. Whether it's efficient and it cools down the entire home, I'm not sure, but the tenant has paid late or installment over the year, and their excuse is that, oh, the AC is not working or it's old, and they want us to completely do a whole new AC unit.
You
So
said
then,
to interrupt you, you said the AC is old, but it's working?
yeah, the AC is old, but it's working.
Well, that reminds me of myself. I'm old and I'm working. Okay, but the issue is if it's old and it's working, then it's working. So the air conditioning doesn't necessarily have to, that's not a mandatory thing like you have to have a heater that heats the house. That's not mandatory. If you do supply an air conditioner, then you have to make it, maintain it. So the fact that it doesn't cool the whole house, well, that's not your problem as long as it's actually operating. So on that basis, I would have it checked, and if it's working within its reasonable limits, then the tenant has no right to withhold rent.
Okay. The second part of the question is the lease is about to end, and we will be providing like the 3-day notice and then requesting for her to move for them to move out. What is the best way to serve the notice? Is it by
Okay, well, there
mail?
is no notice to be served. So let's first talk about what city is this property located in?
Long Beach?
Okay, and this is a single family home?
Correct.
Only one house on the lot?
Correct.
You leased the property to these people?
Correct.
In your rental agreement, did you state that the property was not subject to statewide rent control?
I don't recall. We use
Right.
the one of the car forms for the
Yeah, they
rental
have a
agreement.
box to check. Hopefully that box was checked. You don't serve a 3-day notice. What you do is you write your tenant an informal letter saying, hey, this lease is going to be over on the end of February. We're not renewing it and we expect you to vacate.
Okay, is there the amount of time before the end of the lease that we can provide that notice or that
No, I
letter?
would do it as soon as possible, but there's no specific time at all. In fact, you don't even have to write the letter, but obviously, if you're not going to renew the lease, you want to inform your tenant as soon as you realize that.
Okay. Okay, thank you so much, Dennis.
And thank you. We are moving on to Armando. I'm going to ask you to unmute yourself. No, let's try it again. Armando, try one more time, please. There you go.
Hi, Dennis.
Hello.
Hi. So I have a property. It's in the city of Wilmington, and it's a triplex. And I got a letter, I guess, from the housing authority, and it's asking for me to register the property and pay a fee. Looks like it's a rent stabilization ordinance and just cause ordinance. And I'm wondering, online on the website it says for properties built on or before October 1st, 1978, then these properties are subject to RSO, or is it after?
Okay, well, first of all, Wilmington is really part of the city of Los Angeles.
It is part of the city.
So that's just an area of Los Angeles, just like Hollywood is an area of Los Angeles and Encino is an area of Los Angeles. And in the city of Los Angeles, if you have more than one dwelling unit on a property as you do, then your property is subject to RSO, the rent stabilization ordinance, if it was built prior to October 1st, 1978. If it was, then you have to register your units with the Los Angeles Housing Department. You have to pay their fee. They have the right to inspect your units, etc. And obviously, you're limited to rent increases. Rent increases per year right now are 4%.
Okay, so that's the cap, 4%.
Yep.
It's no adjustment for the CPI.
No, it's 4%. You do get an extra 1% for each utility supplied. So if you supply all the natural gas for the building, or if you supply all the electricity for the building, then you would be entitled to an extra 2%.
Okay, and what about the water?
Water is not counted. It's only natural gas and electricity, and you'd have to supply the entire utility for the entire building.
Okay, I appreciate it. Thank you.
No problem. Moving along to Audrey Smith. How are you? Audrey, are you there?
Yes. Hello?
Hello, Audrey.
How you doing? Okay, thank you. I have well, the tenant been gone for 2 months, moved to Texas. However, he hasn't given the key back. He hasn't paid rent. So my question is, do I have can I just go and move? He left a lot of stuff. He didn't do the work he's supposed to do. So can I just start working on the unit now?
Well, first of all, has he told you, can you call him and ask him, hey, are you gone? Can I have possession?
He told me he was gonna give me the key, but then he'll say things like, "Well, I'm gonna come back," and he did some modifications on the
Right.
property. I'm gonna come back and take that stuff down, but he hasn't done it, and
All right. So he hasn't abandoned the premises based on his spoken word. He
but he
owes you
said,
rent. You need to go forward with an eviction.
Okay, even though he keeps saying he's gonna give me the key.
Well, I mean, you could wait, until your grandchildren have grandchildren.
Okay, thank you.
All right.
Bye-bye.
Okay. I thought I'd be at a Laker game tonight, but they canceled. So on that basis, I'm going to take one more call. And my good friend from New York, Janice, how are you?
Hi, Dennis. How are you?
I am fine, thank you.
Two quick questions. My former property manager neglected to tell me that instead of getting a $100,000, requiring a $100,000 tenant liability insurance policy, they made a deal without telling me for 10,000, and now the lease is up for renewal. I'm no longer with that company. Do I have to give them a 1 month or 2 month notice that it's going back up to, or it's going to $100,000 on a 6 month lease that they're on when that expires?
Okay, so first of all, what city?
Placer County, Roseville.
Okay, so I don't think they have any local rent control for that area.
They
So you
don't.
just present them with another rental agreement that has the terms in it that you want. If they don't want to sign it, then tell them that I'm terminating the lease.
Uh, that can be done as an addendum to the current lease?
You could do it as an addendum, or you could just do a brand new 6 month lease or whatever.
Okay, and did I hear you say last week, Dennis, that I'm unincorporated and a single family property, just one property, that I can move back into that property without or regain the property without paying
When you
one?
say unincorporated, you mean unincorporated area of Los Angeles?
No, of in Placer County.
Okay, if it's a single family residence and they've been there longer than 1 year?
No, 6 months.
Okay, yeah, just serve them a notice.
Okay.
And even if you didn't check the box stating that this property is not subject to statewide rent control, they've still been there less than 1 year, so you can just terminate the tenancy.
Okay, after 1 year, I would have to pay them.
It depends. If you had the exemption language in your rental agreement,
I do.
then you can terminate anytime. You're not subject to statewide rent control. You are the master of your property. And with that, thank you very much. I'm going to end it right here. I appreciate everybody coming out for these Zoom meetings and also, of course, on YouTube Live. If you are in the YouTube, please think about subscribing to my channel. It really does help. And press the button that you like what you're hearing today. And with that, I'm wishing everybody to please have a safe weekend and upcoming weeks. Hopefully all of us here in the Los Angeles area will get through the upheaval that we're doing. And my heart goes out to anybody who has suffered losses. Take care, everybody.